Alternative Dispute Resolution, ADR, has been gaining prominence in Nigeria, especially through its integration into the country's formal legal system. With the establishment of the Lagos Multi-Door Courthouse, LMDC, in 2002, ADR experienced a revitalization, offering a more efficient and culturally resonant method for resolving disputes. The LMDC marked a significant milestone as Africa's first court-connected ADR center, setting a new precedent for how legal disputes could be handled in Nigeria. The model combines indigenous methods of mediation and arbitration with modern legal practices, providing quicker, cheaper, and more amicable alternatives to litigation. This interview seeks to explore the rise of ADR in Nigeria, its impact on the legal system, and its potential to improve access to justice. And to have the conversation on alternative dispute resolution with us this evening is a legal practitioner and conflict resolution specialist, Barrister Ndamzi Ekwulo. Good evening, Legal. Thanks for joining us.
Okay, yes, I'm here. Good evening.
Right ahead, can we have an overview of what alternative dispute resolution is all about?
Okay, thank you very much. Alternative dispute resolution, it's a collection of methods used to resolve disputes outside traditional court proceedings. These methods include negotiation, mediation, conciliation, and arbitration, and early neutral evaluation. Basically, the goal of ADRO is to provide more efficient, cost-effective, and flexible dispute resolution options in a dispute.
I understand ADR.
Hello?
Are you there?
Yes, I'm here.
Okay. Were you saying something, or should I go on?
Yes. Yes, go on.
Okay, I understand that the ADR has been integrated into Nigeria's legal system. But is it a case of the bigger animal swallowing the smaller animal? We've had critics argue that the ADR can sometimes favor the more powerful party. How do you address these concerns about the effectiveness of ADR, really, in achieving truly fair and just outcomes?
Could you reframe your question?
I'm asking to know how effective the alternative dispute resolution is in Nigeria. Is it true that it favors the more powerful?
No. It is not true that ADRO favors the more powerful. ADRO is very effective right now in this part of the world, particularly Nigeria. Nigeria has a strong legal framework for ADRO, and this includes the Arbitration and Conciliation Act, the Nigeria Industrial Court, and the Alternative Dispute Resolution Center. They also play a role in facilitating out-of-court settlements. And we are also aware now that basically in this part of the country, the southern Nigeria, the multi-door courts are also open for dispute resolutions. You know, like we said before, the idea of ADRO is to making sure that parties to disputes find an alternative means of resolving dispute without going to court to litigate. So ADRO is really booming in this part of the country right now, and we advise that parties always seek ADR in resolving disputes.
Let's talk about the processes of alternative dispute resolution. How does it actually work?
Okay. There are there are four mechanisms of alternative dispute resolution. We have the arbitration. In arbitration, parties appoint an independent arbitrator to hear them and make recommendations where necessary. Then we have conciliation. In conciliation also, parties decide the conciliator, who serves as a neutral third party in finding solution to a dispute between parties. This conciliator is a neutral third party who assists parties in initiating negotiations to getting a final settlement. Then we have negotiation. In negotiation, there are direct communication between parties to reach mutually acceptable agreement. In most cases, the agreement may break down and it may get to the point where a conciliator may step in to find a lasting solution. Then also we have settlement conferences. In this type, parties and their lawyers meet with the neutral person. This neutral person may be a judge or a settlement officer, as the case may be, to discuss terms and options of settlement available to parties. We also have a community dispute resolution centers, where we can name as the traditional method of dispute resolution, wherein in our various communities, the chiefs and elders of the community can mediate on a matter involving disputing parties. So these are the various mechanisms or methods of alternative dispute resolution in Nigeria.
Do we have the processes that the courts adopt? For instance, all the parties coming to the court and in the presence of the judge and the jury, they are asked questions, witnesses and all, and everyone is speaking and everyone is listening. Do we have stuff like that, or is it enshrouded in some sort of secrecy and confidentiality?
Okay. You know, first and foremost, arbitration tends to save faith between parties. Arbitration also tends to maintain confidentiality between disputing parties. So one of the advantages of arbitration is that information regarding the dispute are mostly kept confidential. So in arbitrary proceedings, it is never conducted in an open court. But in most cases, a court of competent jurisdiction might order what we call a court-ordered arbitration. And once that is done, an arbitrator will be appointed, and that arbitrator will choose location for the various arbitrary proceedings, which usually happens in confidence. It is not in an open court, unlike what we have in the multi-door court system.
Since some of these processes are confidential, how then can we ensure transparency and accountability, particularly in cases that involve public interest or significant societal impact?
Yes, according to the Arbitration and Conciliation Act 2003, okay, every proceedings, settlements, decisions, as the case may be in an arbitrary proceedings, have the same force as though it was a court judgment. And in the event where a disputing party refuses to adhere to the settlement decision of an arbitrary panel, the injured party is within his rights to approach the High Court of the state, which will in turn give a decision as though the court gave that decision. The court will simply adopt the settlement decision of the arbitrator or the mediator or the conciliator or the negotiator, as the case may be. So that is to say, every arbitrary proceeding that led to a decision of settlement, for example, have the same force and enforcement with what the court can do, because it has a judicial backing, as stated in the Arbitration and Conciliation Act 2023.
What kind of conflicts are resolved in alternative dispute resolution centers, or can be brought to be resolved in an ADR?
Okay. Basically, you know, as humans, in our day-to-day activities, there will be conflicts. So, for ADRO, one important conflict that ADRO tend to mitigate is commercial dispute. If you visit the multi-door court centers, you will see so many commercial disputes in the multi-door centers. Disputes arising from non-compliance to terms of contract could lead to arbitration. And in most cases, parties to a contract can also have a clause or a term in the contractual agreement that in the event where a party, doesn't keep to the terms of the contract, that they will resort to arbitration. And in that regard, parties go ahead to state the duration of the arbitration. In some cases, 30 days. In some cases, if the matter in dispute is contentious, they can do up to 90 days, depending on the situation. So, commercial disputes are mainly disputes that can go to arbitration. Also, family-related disputes can also go for arbitration or ADR or negotiation, as the case may be. An independent evaluator or a conciliator can be appointed to conciliate between disputing families. For example, in a land dispute that does not have criminal elements, ADRO can also suffice. In civil defamation, ADRO can suffice. Situations where maybe interested parties may want to intervene, where, for example, friends are the disputants. Friends also can intervene to settle them out of court. In the instance where the matter already is in court, people can intervene to settle out of court. That is another means of traditional arbitration. So there are so many examples, so many instances wherein alternative dispute resolution can come in. But in criminal litigation, alternative dispute resolution may not do much, because crime is punishable by the criminal code. The criminal code criminalizes crime in Nigeria as in the southern Nigeria, and penal code as in the northern Nigeria. So arbitration, alternative dispute resolution, may not have a force on criminal litigation. But all civil-related matters, ADR can suffice.
Wow. Okay, that's interesting and clear enough. I don't know. We actually practice common law here, apart from court precedents that we also apply. I don't know how much of our cultural influence manifests in the courtroom. But for the alternative dispute resolution, is that adopted also? I mean, cultural influence? Or do we somehow apply Western ADR practices in our own style of alternative dispute resolution?
Thank you very much. Like I said before, here in Nigeria, alternative dispute resolution is regulated by the Arbitration and Conciliation Act 2023. And that act clearly states processes, methods, and types of ADR and as applicable in our claim. Here in Nigeria, we also have a traditional system of arbitration or mediation. A system where the chiefs and elders of a community can intervene on an issue to bring in about lasting peace. A system where a women group in a community can mediate on family disputes. These are traditional ways or patterns of resolving disputes. And you can agree with me that in doing that, cultural influences, cultural ideas, cultural systems will sure influence such decisions, wherein, traditionally people are mediating. Customs and tradition will sure have its way. But if it has to do with commercial arbitration, basically the tenets of the Arbitration and Conciliation Act will apply. And I and you know that Nigeria practices the common law system. So all the rules of arbitration as applicable in the West are also applicable here in Nigeria, subject to ratification though. So that is the position of culture of traditional arbitration.
How much would you say that Nigerians appreciate alternative dispute resolution?
Yes. Here in Nigeria, alternative dispute resolution is still a work in progress.
We still have persons who, start off with the ADR and over time move the matter to the courts.
I didn't get that.
I said, do we still have cases where people, after passing through alternative dispute resolution, go back to the courts? Or
yes,
go to the courts, assuming they've not been there, have been issue?
Yes, we have so many of such cases where parties who initially appreciated ADRO weren't satisfied with the settlement. At that point, the Arbitration and Conciliation Act allows you to go back to the court to vent your grievances and possibly seek relief.
But is it possible that ADR can be more effectively integrated into the traditional litigation process, at least to encourage earlier resolution of disputes without undermining the rights of parties to seek judicial relief, going back to the courts?
Yes, yes. We encourage government to sponsor the sensitization of Nigerians, because so many people are still interested. So many doesn't even know that we have an ADR system that can give us a quick resolution of dispute, an ADR system that is cheap, because ADR is cheap. It helps save faces. So Nigerians need to be aware of ADR processes. Nigerians need to appreciate ADR processes, because now if we can all agree, Nigerians are litigants. We like approaching the court at first instance, but it is kindly advised, even in most of the court rules in Nigeria. So, for example, here in Rivers State, you cannot approach the court ab initio without, first of all, exploring the processes of ADR. If you approach the court without ADR processes, the court will ask you to go back and do arbitration. So arbitration is really recommended, and it is advised, because it is quicker, less expensive, and it saves relationships.
Barrister Ekwulo, in selecting mediators and arbitrators, what qualities should be considered, or qualifications should be put in consideration in their selection?
First and foremost, the Arbitration Act says such person, such professional must be a lawyer, an accountant, or a chartered secretary. Then there are court-ordered arbitrators, okay, and the court considers licensing. The arbitrator they are appointing, is that person a licensed arbitrator? Like, for example, we have a corporate body here in Nigeria called the Institute of Chartered Mediators and Conciliators. This is a professional body that trains and certifies professionals of ADR. We have them at the associate level. We have them at the membership level, and also we have them at the fellowship level. We also have the Chartered Institute of Arbitrators. These are professional organizations saddled with powers to train and license arbitrary professionals here in Nigeria.
Okay, I would wish that you increase your voice a bit. With the advent of technology, and in order to still remain relevant, do we have options of online dispute resolution platforms, or must we go physical at all times? I'm talking about the future.
Okay. Yes, with the advent of technology, it has become easier to anchor arbitrary proceedings in a situation where maybe disputing parties are not in the same location or not resident in the same country. For example, in a commercial dispute where parties to the dispute are not resident in same country, arbitrary panel can adopt the Zoom network. They can adopt the Google Meet. Like, I have attended an arbitrary proceedings where we used Google Meet, a party was in Ghana and the other was in Nigeria. So Google Meet technology have made it so easier for parties to move on ADRO processes quickly. But in most cases, there are disadvantages of using the technological means of resolving ADRO. In case where a party is being aided, how do we know? So these are the advantages and some of the disadvantages of using technology in ADRO processes.
Thank you very much, Barrister Ndamzi Ekwulo, for joining us on Alternative Dispute Resolution on this segment of Signature Evening.
Thank you very much. Thank you for having me.
Signature TV, news in your pocket.